Welcome to Ducks in a Row, the Estate Planning Guide.
Welcome to the Ducks in a Row, the Estate Planning Guide with attorney Erin Nunes, one of the managing partners at Surprenant, Beneski, and Nunes Estate Planning and Elder Law. Erin and her team of dedicated legal professionals are helping southeastern Massachusetts families plan for tomorrow today. I'm your host, Lisa Mosby, and I'm here with Erin to dive into wills and trusts and what actually makes sense for your family. The team at Surprenant, Beneski, and Nunes Estate Planning and Elder Law are local experts dedicated to turning complex legal hurdles into clear, proactive roadmaps for adults and their children. Erin, I appreciate you being with me again today. Are you ready to get into what matters most?
Absolutely.
Erin, how common is it for families to not have a plan in place after a parent's diagnosis that could potentially lead him or her to become legally incapacitated?
Far too common, sadly. It's very difficult. It's been very difficult historically for families to open up and talk about, what happens if I get sick? What happens if I'm incapacitated? What do I want for my long-term care? What are my funeral wishes? Things like that have been very hard for families to open up and discuss options. So there are many, many families out there who have no plan in place and a loved one becomes ill, and then they have to start scrambling because they just don't know what they would have wanted them to be doing.
And then in those first 90 days after a diagnosis, what are the biggest mistakes Massachusetts families make that put their assets at risk?
They just start giving things away. It is very common for people to say, I just want to give my house to my kids, or start giving large sums of cash away. Not because they're trying necessarily to hide anything. They just don't know the rules and the implications of doing those things. And sometimes they start giving things away, and then their loved one gets sicker, needs care, and they come to see us, and then we're having to untangle a real mess. And sometimes there are very real lasting financial implications when things like that happen. We can't always undo it, sadly.
Mhm. And I know many families wait a bit too long because they aren't sure if a diagnosis means it's just too late. How do you determine if a parent in Massachusetts still has legal capacity to sign a power of
So
attorney?
we're going to meet with them. We can meet with them in the office if that's appropriate, if they feel more comfortable at home, or certainly if they're in the hospital or an assisted living setting, we can come to them. But we're going to chat with them. We try to make it easy, not intimidating, not scary, but we'll talk to them. Do they recognize? Do they know who they are? Do they recognize their loved ones? Do they have a general sense of what their assets are? Are they oriented to time and place? Things like that. If by any chance we're kind of on the fence about whether the sufficient level of capacity exists, we will request an opinion from their physician about whether or not, from a medical perspective, they feel like they have the capacity to sign those documents.
That makes sense. And I know many, many families fear the 5-year look back rule. For a family just starting this journey, how do you explain what is actually safe to do with their assets today?
So, certainly, anytime you are spending money for your own benefit, that is not going to implicate the 5-year look back period. So, if a parent is spending assets to improve their home, make safety improvements, if they, have a really old car and they need something safer, things along those lines, that is almost always going to be perfectly fine to spend money on. There are some exceptions to the 5-year look back rule. For example, if you have a disabled child or a caretaker child, those are options that we can look at for being able to preserve assets. But generally speaking, if your family situation doesn't allow for us to use one of those limited exceptions, then you have to be really careful about just giving assets away. A lot of times somebody gets sick and assets just start flowing, money starts being given away, just because they don't know any better. They don't know the implications of doing that. And sometimes, there's a diagnosis, hundred thousands of dollars are given away, and then 2 or 3 years, their health has deteriorated to a point where they now need long-term care. And all that money that they gave away during the 5-year look back period is going to be problematic.
And many parents just want to put the kids' names on the deed. Why is that so often a dangerous move in Massachusetts? And what's a better alternative?
Absolutely. We hear that all the time. And there's lots of different reasons why it is not my favorite planning strategy. The first is you are giving a piece of your home away to someone else. So now that is theirs. If they got divorced, if they had a creditor issue, if they had a lawsuit, you might find yourself in a situation where you are losing a piece of your home to that creditor, to that divorcing spouse. You may still have the right to live there, but no one wants to own their home with a creditor of their child or their child's divorcing spouse. So that's not fantastic. It can also present a problem from a tax perspective. So there can be capital gains tax implications when a property is later sold if it's been given away, either a portion of it or it in its entirety. That can cause capital gains tax issues when the property is sold. So there's lots of different reasons why that type of outright gifting during your lifetime, in my opinion, just doesn't provide enough protection for the senior. And that's who my client is. So I want to help them look out for their own best interest. Sometimes even a wonderful family situation can change over time, and a loved one becoming ill can change your family dynamics in ways that you wouldn't have always anticipated, and that can be a real problem. So rather than that type of outright gifting, using an irrevocable trust to protect assets from the cost of long-term care provides a lot more flexibility and a lot more protection for the senior. And we are able to change beneficiaries if divorces do occur or things like that, that you might not be able to undo with just that type of outright gifting.
Let's talk about an irrevocable trust. Can you give us a definition of that? And at what point should somebody consider setting that up instead of using a will?
So, an irrevocable trust is typically used for asset and creditor protection. It is designed to preserve the assets that are in it from the cost of long term care and other creditors that you might have. When you transfer assets into an irrevocable trust, it gets that 5-year look back period ticking. So if you find yourself in a situation where you need long term care and you are applying for Mass Health has the right to look back into your records, your financial transactions, to see what you've done with your assets in the last 5 years. And if you have given something away, either outright or to an irrevocable trust, that's going to create a problem during that look back period. So the earlier in time you can start that type of pre planning, the more likely it is that it's going to be successful and actually protect your assets. So typically, I recommend late 60s, early 70s. Once you've retired, you have a sense of what your retirement income is going to look like, what quality of life you want to have, what your expenses are going to look like. That's a good time to start thinking about whether an irrevocable trust is a good fit and matches what your goals and concerns are.
Sure, that makes sense. If a family misses that 90-day window, what does the plan B guardianship or conservatorship actually look like in the Massachusetts court system?
So, when someone loses capacity and they don't have documents like a good power of attorney, a good healthcare proxy, then someone has to petition the probate and family court to become their guardian to make medical decisions, and their conservator to make legal and financial decisions. That process can be costly. It can be time consuming. It's public. It gets published in your local paper that you've lost capacity and so is petitioning the court to become your caregiver, essentially. Um, so for most families, they want to avoid that process. They want to be able to choose, who do I trust? Who is going to step into my shoes, honor what my wishes are for my health care, for how my assets should be spent. So having that good power of attorney and healthcare proxy in place is critical. But if you can't do that, if the person just does not have the capacity to be able to execute those estate planning documents, then guardianship and conservatorship are the court processes by which the court says who gets to do those things for you.
I have a thought. Like, I hear stories about people having anxiety about giving away power of attorney or having somebody step in and make decisions on their behalf and losing control. Can you speak to that?
So, generally, with a durable power of attorney, there is shared decision making. So, the powers of attorney that we execute in our office become effective immediately, meaning you could give your agent that power of attorney and they could go start using it on your behalf right away. Now, not everyone is ready for that. For people who are coming in to do their planning at a bit of a younger age, where it isn't really needed for someone to be acting for them, we hold powers of attorney in our office if our clients want us to. So we would release it for them, if they gave us permission to do so. But if they lost capacity, their agent would need to bring a letter from their doctor documenting the incapacity, and we would give them the original to start using at that point in time. So that's a little bit of a check and balance to make sure that it doesn't fall into the wrong hands, it isn't misused, or if many, many years have passed, that it isn't just lost or damaged over time. We have that original for safekeeping. But technically, if you wanted them to, they could use it right away.
And then if a parent's health takes a sudden turn for the worse, is it ever truly too late to protect some assets?
Sometimes, but most of the time, there is something that we can do. So even if you find your family in a crisis scenario, mom or dad or your loved one, they're on the eve of a nursing home stay, or they've had a fall, they had a hospitalization, now they're in rehab, and it just really is not safe for them to come home, and they're going to be staying long term. Come and see an elder law attorney right away. We may not be able to protect or preserve everything last minute, but if their goal is to try to preserve as much as possible, we can provide them with the options to try to stretch that money as far as possible in the hopes that there may be something left for the beneficiaries.
And Aaron, are there specific Massachusetts laws like the Homestead Act that give local families a unique advantage if they act quickly?
Unfortunately not. So, the Homestead Act in Massachusetts will protect your home from creditors and lawsuits, meaning someone can't sue your house out from underneath you if you got into a fender bender or something along those lines. But the Homestead Act in Massachusetts does not protect your home from the cost of long term care. There are states where that is an option, but unfortunately not in Massachusetts.
Here's where I want to wrap up today. Is there any final thoughts, things that I missed asking about that you want to share with our audience, just to give them some peace of mind and some clarity about why it's so important to at least have an attorney's phone number in their wallet, and second choice would be to make sure that you've started the planning process.
Yeah, absolutely. Knowledge truly is power. Whatever your goals are, whatever your concerns are, you want to make sure that you understand the implications of planning, of not planning. What does that mean for your family? What does that mean for your long term care? what's going to happen if I do this? What's going to happen if I do that? So coming in and sitting down with somebody and again, taking all of the complex rules that there are in elder law and estate planning and applying them to your specific goals, your concerns, that is so critical because too many times people do things without truly understanding the implications that it's going to have. And that can create way more trouble down the road than is necessary. So just educating yourself is so important.
Erin, thank you so much for the conversation today and for your guidance. I so appreciate how you walk us through all of
You're
these
welcome.
different nuances with estate planning.
Happy to do it.
Folks, thank you for joining us on Ducks in a Row, the estate planning guide. If today's episode was helpful, please like, share, and subscribe so that we can help more Southeastern Massachusetts families. Don't wait for a crisis to start your roadmap. You can find more educational tools or schedule a consultation at myfamilyestate.planning.com. As Erin and the team at Surprenant, Beneski, and Nunes say, the best time to plan is now. We'll see you all at the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.